Hello, everybody. As Catherine mentioned, my name is Peter Ryan, and my partner, Aaron Flores, and I will be giving the presentation today. We're both attorneys out in California at the law firm Flores Ryan, LLP. We're a law firm that specializes exclusively in construction law, and we thank you for joining us today. Aaron, could you go to the next slide, please? So to start, we're going to go over the agenda for today. We're going to start with just going over, well, what is a mechanics lien in the first place? Then we'll go through prerequisites to recording a mechanics lien, then the pre-litigation use of mechanics lien rights, then the mechanics lien foreclosure lawsuit process, some common mechanics lien issues that we see, and then finally, an overview of mechanics lien outcomes. Basically, where do we expect to end up with liens? We're going to keep the discussion broad. Mechanics lien rights exist in every state in the United States, but the deadlines and some specifics vary by state. So we're going to keep the discussion broader, but there's a lot of information on level set regarding specific deadlines and requirements for each specific state. Let's go to the next slide. So what is a mechanics lien? Here's a picture of a California mechanics lien. This gives you an idea of basically what they look like. A mechanics lien at its core is a recorded interest in property, basically to secure the value of labor, equipment, and materials incorporated into the property through the construction process. Physically, as we just saw, a mechanics lien is a document. This is a document that states under oath the amounts a construction professional is owed, and the document is basically filed with the county recorder in which the property is located. And the point is to put the whole world on notice of this lien claim, and that the property, that any equity in the property is now securing the amount that is owed for the lien. Mechanics lien secures payment for work in the same way that a deed of trust or mortgage secures a loan on a property. If not paid, you have the right to initiate a lawsuit to foreclose on the lien, forcing a sale of the property in question so that you can be paid from the proceeds from the sale of the property. As a practical matter, the sale of the property to pay the lien rarely occurs. This is because the leverage generated by the potential of a forced sale of the property is usually sufficient to secure payment without going through the whole process. Additionally, while a lien is valid, the owner may be forced to pay off the lien if they want to either borrow more money secured by the property, refinance the property, or sell the property to a third party. This again can encourage payment without actual foreclosure of the lien, or can lead to payment of the lien obligation from an escrow in the context of a sale of the property. Who has these mechanics lien rights? Basically, anybody who permanently adds value to real property through the construction process can record a lien. There are some exclusions to this. First and foremost, anybody who has an actual ownership interest in the property cannot record a lien. So if, for example, you enter into a partnership to flip a property or something like that, get in a dispute, unfortunately, because you are an owner of the property itself, you don't have lien rights. Another big exclusion category is parties that are not actually legally entitled to perform the work that they're claiming payment for. The biggest category here, of course, is anybody who is not properly licensed to perform the work that has been done. And then finally, parties who fail to take the required steps to secure their lien eligibility. This varies by state, but almost all states require, at least depending on the party, preliminary notice be given to the owner is a condition to recording a lien. So if you haven't taken the correct steps to preserve your lien rights, you may not be eligible when you otherwise would be. Why would we record a lien? Well, this seems pretty obvious, but there are two primary reasons to preserve your lien rights and, if necessary, to actually record a lien. The first is obviously to secure your claim to payment with any equity in the property. The second, which is also very important, is to ensure the necessary formal communication to reduce and accelerate the resolution of disputes. This second aim is especially important when there are tenants, multiple owners, or construction lenders involved, because in that case, communication becomes more difficult, and it's important to have these formal communications in order to ensure everybody's on the same page with respect to timing of payment and any disputes that exist. This purpose of communication is even more important for subcontractors or anybody who doesn't happen to have a direct contract with the owner itself. Let's jump to the next slide.
So now we'll talk some of the prerequisites to recording the mechanics lien. Like Peter mentioned, in almost every state, there's a requirement to have some form of preliminary notice. And conceptually, this just makes sense. The power of the mechanics lien is so substantial that most states will require a lien claimant or potential lien claimant at the beginning of the project to notify the project owner that they're there performing work on the project. And this idea is that now the owner is informed of who's actually performing work. And now that they're informed of who's actually performing work, they have legal notice as to who can potentially record a mechanics lien. Some states make this preliminary notice so important that it can be a violation of law not to serve a preliminary notice. That's the case in California. And some states only require it if there's no direct contract with the owner or if the claim exceeds a certain amount. The best practice really is to always give preliminary notice. There's no harm in giving the preliminary notice, but if you fail to give preliminary notice when you're required to give it, you can potentially be out of luck in terms of your ability to record a mechanics lien because you haven't satisfied this important prerequisite. When it comes to preliminary notices, you obviously always want to notify the project owner, but depending on whether the construction project is funded by a construction loan, you could also potentially have to notify the construction lender with the preliminary notice as well. Another important prerequisite in some states, but not all, is serving a notice of intent to lien. And in California, there's not a legal requirement to serve a notice of intent to lien, but in other states like Arkansas, Colorado, Connecticut, just to name a few, there are these requirements to serve a notice of intent to lien prior to recording your lien. Now, while I just said in California, it's not the law that you have to serve a notice of intent to lien, it's very common in your contract, so not a statutory obligation, but a contractual obligation, that a general contractor or an owner will require the other party to serve a notice of intent to lien prior to actually recording the lien. So not only is it just a good due diligence step to give notice of an intent to record a lien, in some states you're actually going to be legally required to serve a notice of intent prior to recording your lien. In most states, after you've done your preliminary due diligence, you've served a preliminary notice, then you got to the point of getting ready to record a lien, and now you're getting ready to record that lien. There's going to be certain completion requirements, and they really fall into two different categories. The first is completion of your own work, meaning you've completed all your work or you have completely stopped work. You can't record a mechanics lien while you're still continuing to perform ongoing work. So that's very important. So not only do you need to complete your work, I've also included here that you need to preserve any contractual claims. Many times with clients, they'll have a dispute with an owner or a general contractor. They'll stop their work because they haven't been paid or whatever reason, but there could be certain contractual claim procedures that they have to follow. So preserving your contractual claims through notice to the owner or the general contractor is also going to be an important prerequisite. So you complete your work, you notify the owner and the general contractor of all your claims. Now you have made sure that you're in a posture where you can legally record the lien. I mentioned that there's a second category of completion that's also important in terms of prerequisites, and these are the deadlines to record the lien. And so some of these deadlines can be actual project completion, that the project has gotten fully completed. And now there's, let's say, a notice of completion that's been recorded, or perhaps there's not one recorded. But now that's going to start a deadline to record the lien. Occupation or use of the project by the owner with a work stoppage. So let's say the project is 95% completed, but they stop work and the owner begins to occupy it. That can start a deadline to record a lien. Also, a stoppage of work for a continuous 60 days. Let's say the project is halfway through and the owner decides to stop work continuously for 60 days. That could trigger the commencement of a deadline to record your lien. It could trigger completion of the project. And then, of course, a notice of cessation of work after a stoppage of work for 30 days or more. So we have these prerequisites to recording the lien: the preliminary notice, the notice of intent, but we also have these important completion prerequisites, which include completion of your work and preserving those notices of contractual claims, and also being mindful of these deadlines to record the actual lien itself. So now Peter's going to talk about pre-litigation use of mechanics lien rights.
Peter, before you get started, excuse me, we have a couple of questions that just came in during that part, Aaron.
Oh, great.
Jody asked, we do electrical service work in California. What would we consider for completion deadlines?
Yeah, so they're a little bit complicated, but what I can generally tell you that is, and when a project is completed and there's a notice of completion, the general contractor is going to have 60 days to record their mechanics lien after the notice of completion. Any subcontractor is going to have 30 days from that notice of completion to record a mechanics lien. Those deadlines change if the project is completed, but there's no notice of completion that the owner records. In that instance, all parties, including the general contractor and subcontractors and suppliers, are going to have 90 days to record a lien from actual project completion. So if there's a notice of completion, there's certain deadlines that apply. If there's not a notice of completion, there's going to be other deadlines that apply. Feel free to reach out to us for the specifics of those, or you can jump on the Level Set website for the California mechanics lien as well.
Thanks, Aaron. And someone asked about receiving CLE credit in the state of Colorado. If you can email me, I will type my email in the chat box, but all these CLEs are accredited in California and Texas pending approval. And so check with your local state bar for the requirements to submit for out-of-state credit. And they typically have reciprocity or approved jurisdictions with California or Texas. So that is that. And then are either of you able to see the Q&A panel? There's a lengthy question posted in there. I just wanted to see if you could get your eyes on it, or I can read it all out loud.
I can't see it. Can you see it, Peter?
Yeah, I can see it. Let me look at it really quickly.
Yeah. Aaron, while he's reviewing that, there's one other that just came in. Can you work on the project and still have a lien recorded? Or do you have to finish work completely and not put a pause to it?
Yeah, so the general rule is that you have to complete your work, and there's somewhat of a trap that contractors can step into is if they've recorded their lien and then they continue to perform work, that lien that has been recorded is no longer valid. And so sometimes if a party stops, they have a lien and then they work something out, but not all the way, they get back to work. They think they have a lien, but actually they don't. And so that's the downside. The good news is that if the contractor is continuing to perform work, then even though they've recorded a lien already, they can release that lien and they're still within the time frame to record a new lien. So if they record and go back to work, that lien's invalid, but they can always still record a new lien because now they're within the time to record a lien because work is still ongoing.
And taking a look at Mr. Richard Stott's question regarding potentially lien rights within New York for an architect. We can't speak to New York directly because we don't necessarily know the specific law there. In most states, with respect to architects, there's something called a design professional lien in addition to the mechanics lien rights. And the difference is design professional liens occur before the project is started. And generally, once the project is started, a design professional lien can be converted into a mechanics lien. So you'd have to double check with respect to the New York rules, but that's the general answer to that question. So thank you for those questions. We'll keep going here. Next, we're going to cover, as Aaron mentioned, pre-litigation use of mechanics lien rights. The primary goal, of course, in exercising your lien rights is to resolve disputes and secure payment as early as possible, and certainly before a lawsuit is filed. So focus on your pre-litigation actions is absolutely essential. This starts with preliminary notice. Preliminary notice itself is one, and this is one of the reasons that we recommend preliminary notice be given, whether or not it's legally required, be given in all cases. Just giving preliminary notice provides a degree of protection as it ensures that the owner is aware that you're on the project and that you have lien rights, especially if you're dealing with an unsophisticated owner. They may never have heard of a mechanics lien before. They might not know what that is. So by sending the preliminary notice, you're sending the message right away. Hey, I'm adding value to this property. I have lien rights, so please behave accordingly. Further, with respect to subcontractors, a preliminary notice should encourage an owner to require lien waivers as a condition to payment for work provided by subcontractors to the general contractor. This reduces the risk that a general contractor will collect money from the owner, but fail to timely pay subs. If there isn't a requirement for waivers to be given, well, then sometimes the GC may be tempted to collect money and delay paying the subs to use that money for other purposes. They can get behind, and that can cause many problems. The next time to flex your lien rights is as soon as payment becomes delinquent. This is a key time frame when you want to maximize the potential leverage of your lien rights. The lien only provides leverage to the extent that the owner appreciates the consequences the lien presents. So the name of the game is to clearly communicate the imminence of the lien and the effect the lien will have on the property immediately as soon as payment becomes delinquent. The best way to do this is via a notice of intent to lien, coupled with follow-up, clearly communicating your lien rights and intentions. In some states, as Aaron mentioned, a notice of intent to lien is required by statute. Such a notice can be provided in any state. If the notice of intent does not elicit the response hoped for, payment for that matter, we recommend following up with the owner directly, or at least considering doing so. After the notice of intent is served, if you follow up the owner, that gives you the opportunity to explain, first of all, why payments are due and why they're overdue. The intent itself may not have the detail required to really explain what the issue is. It also presents the opportunity to reiterate your lien rights, and if necessary, to emphasize the consequences should you be forced to actually file a lien. Sometimes this extra push is what's necessary to resolve a dispute early. If you can resolve it before actually recording the lien, obviously you're going to save money, time, and the need to release the lien once you've been paid. There's a major caveat to following up with pre-lien procedures before going ahead and recording the lien, and that's that you need to watch your deadlines. You only have so long after a dispute arises to actually go ahead and record a lien. Those deadlines generally are tied to project completion. So if you're coming up against the deadlines, you should make sure you don't wait, make sure you record the lien so that your lien rights don't expire. The next step where it's very important in pre-litigation procedures is to maximize pressure upon actually recording a lien. Recording the lien itself will cloud title, and in addition to formally securing your claim, should add pressure to the owner to ensure the delinquent payment is resolved. But as with the notice of intent to lien, the leverage provided by recording the lien is dependent on the owner's appreciation of what has been done and the potential consequences. Just because the owner receives this lien in the mail doesn't necessarily mean that the owner really appreciates what that lien means and what the consequences are. If they don't appreciate the consequences, it may not have the intended effect. You can do this as with pre-lien procedures by contacting the owner directly, or by sending a demand letter, or by having an attorney send a demand letter for that matter for you. At this point in the process, we do recommend involving an attorney. One, because once you record a lien, you only have so much time to foreclose. So if you're going to take that step, you want to be prepared to do so. And two, now that you've recorded a lien, if that is not eliciting the pressure necessary to get things paid, it may take a demand letter from an attorney as the final kind of step in pressure to hopefully resolve this dispute before you have to actually file a lawsuit. And with that, let's go to the next slide. We're going to talk a little bit about recording the lien itself.
Hey, before you turn over the next slide, there are a couple questions from people in Pennsylvania and Illinois about certain things there. So if you want to say a comment about different state law.
Let's see here.
Says, is Pennsylvania different than California law you were talking about a few minutes
Yeah,
ago?
so Pennsylvania is going to have different specific rules with respect to liens. So the deadlines may be different, and whether or not a notice of intent to lien is required, and the preliminary notice requirements are going to be specific to that state.
And then a question from Illinois. It's about, like, do you provide waivers or and end up not getting paid for that progress payment? Do I lose my lien rights to that progress payment? Probably similar in Pennsylvania.
Yeah, so in most states, the way waivers work, there are conditional waivers and unconditional waivers. If a waiver is conditional, generally, it does not waive rights unless you are actually paid. If the waiver is unconditional, then even if you haven't been paid, yes, you are going to lose your lien rights. So while you may still have breach of contract cause of action against your direct customer, you're not going to have lien rights if you unconditionally waive those rights via a waiver.
Okay, one more. How long should the account age before submitting a lien?
So it really depends on what the status of the project is. Generally, lien rights, or the outward limit at which a lien can be recorded, is going to be tied to project completion. So if you are not going to perform any more work, you might record a lien during the project. The most important thing to do is to make sure that whatever the deadline for your state is to record a lien, that you meet that deadline. So it's not necessarily going to be tied to the age of the account rather than the status of the project.
Okay. Sorry, there's several questions coming in, but she asked part 2 of her question. We have master contracts with GCs that have in the contract that the sub is responsible for any costs the GC incurs due to the sub filing a lien. Is this legal?
It would depend on the state. Generally in California, that would not be enforceable to the extent it is considered to preclude lien rights. If the lien is frivolous, in that case, well, then it would be potentially enforceable, but they're not going to, in California, be able to claim costs against you for validly asserting lien rights.
Thanks, Peter. We will address other questions at the end of the program.
Okay, yeah, I know there's a bunch coming in. So yeah, we'll keep going here and talk a little bit about recording the mechanics lien. And of course, Level Set is available to assist with a lot of this process, but still good to go through it just so we kind of understand what the process entails and what exactly is being done. First and foremost, the most important thing is to calendar that deadline for recording the lien. And Level Set also has tools for identifying in the context of your specific state exactly what that deadline is. But keep in mind, if you fail to act in a timely manner before the lien recording deadline for your project has expired, you're going to be out of luck with respect to your lien rights. The next very important thing, and this is going to be relevant whether or not you use Level Set, is making sure that the lien amount is correct. Remember, you can only include in the lien the reasonable value of labor, material, and equipment incorporated into the project. So things that you can't include, you may ultimately be entitled to interest, but that would not be stated in the principal lien amount stated in the lien. Once the lien is prepared and before it's recorded, the lien must be served on the owner of the property and depending potentially also the general contractor, and if there's a construction lender, the lender. So basically, not the original copy, but a copy of the executed lien needs to be served on these parties. Once the copy of the lien is served on these parties, then you can sign the verification, verifying that this has been served on the parties, and then the original of the document is sent to the county recorder for recording or brought to the county recorder for recording. And again, those two steps can be handled directly through Level Set, which obviously is very convenient. Finally, once the lien has been served on the parties and recorded, the final step is to calendar the deadline to foreclose the lien. And again, this is a deadline that through Level Set system you can track, but you can also track yourself. And even if it's being tracked in Level Set, you got to make sure you're paying attention to it so you don't blow the deadline. And in that interim period, from the point when you record the lien to the point where you have to file a lawsuit, that really is the time when you want to apply as much pressure as possible. Hopefully receiving the lien itself is going to be enough to get the parties to pay. But if it's not, then it's time to try and follow up, send a demand letter, do whatever you need to do. So hopefully you can resolve this dispute before you have to actually file a lawsuit to foreclose the lien. And with that, Aaron's going to go through the lawsuits.
Thanks, Peter. So here's just an exemplar of a mechanics lien foreclosure complaint. It looks just like a regular complaint in civil court, but traditionally it's going to be paired with other causes of action. So you see cause of action on the right-hand side there, complaint 4. Item number 5 is foreclosure of mechanics liens. But generally we're going to pair it, like I said, with other causes of action. For example, breach of contract, like Peter had mentioned earlier, some common counts, open book account stated, and reasonable value of materials and labor. But this is what the lawsuit or the complaint that's filed looks like that starts the lawsuit. As Peter mentioned, there's a limited amount of time to file the lawsuit to foreclose on the property. Otherwise, the lien goes stale. In California, the general rule is that you have 90 days from the time you've recorded the lien in order to file your lawsuit, your mechanics lien foreclosure complaint. And if you don't file it within that time, now that lien is stale, meaning that it's invalid. It has to be released and it has no legal effect. So you want to calendar that deadline for the 90 days. And like Peter said, that's really your window of time to push the parties to get payment and to use that deadline to your advantage as a leverage point. You also want to consider other payment remedies. I just mentioned, I showed you the complaint there. It has other remedies. 2 that were not on there were stop payment notice enforcement and a payment bond claim enforcement. It's not the purpose of this seminar to get into those, but suffice it to say that a stop payment notice is available in certain states that actually requires the owner to set aside monies from their construction fund to pay you, and that's an additional basis of security. On certain projects, specifically public works of improvement, the owner will require the general contractor to furnish a payment bond for the purpose of paying any subcontractors or suppliers. And so these are other forms of payment remedies that you can proceed forward with concurrently with your mechanics lien foreclosure complaint. So you want to consider those. But essentially the process is that you prepare the complaint, you file that complaint with the appropriate court. In California, it's the Superior Court of California, and then you serve that complaint on the owner and any other parties who are named in the complaint. Once that is done, the lawsuit process has commenced. And in terms of pursuing your mechanics lien claim, there's an additional important step you have to take, which is to file, record, and serve what's called a notice of lis pendens. And that is just another document that's recorded with the county recorder's office that tells the entire world, not only was there a mechanics lien recorded, now there's actually litigation pending to enforce that claim of lien and to foreclose on the property. And the purpose of the mechanics lien foreclosure lawsuit is simply to enforce the claim of lien, and enforcing that claim of lien ultimately results in a judicial foreclosure of the property from which payment is made to the lien claimant. And so we're telling the whole entire world that that notice of lis pendens, that process has started. The owner here has an option. Once you get the lawsuit filed and served, and the notice of lis pendens is filed and served and recorded, the owner can either pay you and dismiss your lawsuit, or if they're pretty sophisticated, they can obtain what's called a mechanics lien release bond, which is simply a bond that's recorded on the property and is basically substituted in place of the property. And so the owner purchases the mechanics lien release bond, records it, serves it on the parties, and now in the lawsuit, the lien claimant, the subcontractor or general contractor, changes the name on the mechanics lien cause of action from the owner now to the surety who has issued that mechanics lien release bond. And for the contractor side who's enforcing the mechanics lien, it really makes no difference. Their claim is now secured through a release bond that is fully able to pay out the amount of their lien. And for the owner, now the lien is off the property and they can continue forward to do whatever they want to do. As the lawsuit goes forward, it'll either settle, which statistically contractors the odds are in their favor that most lawsuits will settle and not go to trial. But if the claim is not settled, it will go to trial. And like I mentioned before, you will obtain judgment, and that judgment is an order for judicial foreclosure of the property and an order to pay you the amount of your lien from the proceeds of that sale. Clients always ask me, what can we do to try to make the lawsuit process as efficient as possible, whether it's to get it settled immediately or if we're at trial? How do we do this as efficiently as possible? And my response to them is always the same, is the strength of your case and the strength of getting it settled efficiently and earlier depends on your ability to prove your case today, right now. Can you hand over an evidentiary prove-it package that has every document that the owner or general contractor or the construction lender may need in order to evaluate your claim and determine whether it's valid and whether it should be paid? And so putting together an evidentiary prove-it package before you file your mechanics lien foreclosure lawsuit and having it available during the pendency of that lawsuit to give out and prove up your claim is critically important to making your process as efficient as it can be. But this is generally the mechanics lien foreclosure lawsuit procedure.
Next, we're going to cover common mechanics lien problems. As you may only have one opportunity to record a mechanics lien for a delinquent payment, it's important to keep in mind the common mistakes that may render the lien invalid. The first issue, you can go to the next slide here. So we're just going to cover a few of the main issues that we see with liens. Generally, when a lien is recorded, initially, if you don't have to file a lawsuit, these things don't really come up. But if you are forced to file a lawsuit or there's an attorney involved on the other side, all of a sudden you get these technical challenges to your lien. The first issue we commonly see is inadequate preliminary notice. The most obvious version of this is you didn't give preliminary notice and you were required to do so. Another issue we see is preliminary notice not given in a timely manner. In the majority of states, it's 20 days from the start of your work that you must give preliminary notice. If you are late in doing so, your claim could be completely barred or partially barred. Another thing that we see is preliminary notice not given to all the required parties. If there's a construction lender involved, usually the lender must also receive preliminary notice, but especially if you're a subcontractor, maybe you didn't take the time to figure out whether or not there was a lender involved before starting the project. Unfortunately, failure to serve all the required parties can invalidate the notice and then invalidate any lien that is filed later. The next biggest issue we see is blown deadlines. So not just with respect to preliminary notice, but with respect to the other lien deadlines that apply. What are those deadlines? If a notice of intent to lien is required, there are deadlines associated with that. As we've talked about, you only have so much time after project completion to record the lien. And then finally, once you've recorded the lien, you only have so much time to go ahead and file the lawsuit to foreclose the lien. So if you don't record the lien in time or fail to file your lawsuit in time to foreclose the lien is going to either never be valid or be stale and be unenforceable. And at that point, you really have no choice but to file a release of lien, even if you're still owed payment, which obviously adds insult to injury. Another issue that we see, and we briefly mentioned this earlier, is an improper amount claimed in the lien. Remember, you can only claim the reasonable value of labor, services, materials, value added to the project in your lien. Intentional overstatement of a lien is one ground to invalidate a lien. Things that we see that are improperly added to the lien amount are claims for lost profit on work not completed. And that usually happens if a contract is improperly terminated and then a lien is filed. Claims for attorney's fees or interest on the lien amount. While you may be contractually entitled to these and perhaps may be able to recover them in the context of a lien lawsuit, only the principal amount due can be included in the lien. And then other claims not associated with construction-related services. So one common example we see is with respect to remediation contractors. A lot of those companies also offer storage services for people's property while they're performing work. They cannot include those in the lien because those are not construction services. Those are separate services for the storage of property. Another issue that I've seen more often than I would hope to expect is the wrong property lien. This is more common in the case of a material supplier that isn't necessarily performing work on the project itself, maybe just delivering materials to the property. Usually it happens when the property owner happens to have a different address than the project address. And obviously, if you recorded the lien on the wrong property, it's not going to be valid, and you likely are going to let the deadlines run on recording the lien on the proper property. So you wouldn't think that would happen, but it happens more than you would think. Another problem we see is over leveraged property. This isn't necessarily a bar to the lien, but it's important to keep in mind. And I guess it's another consideration if you are going to go ahead and record a lien and expect it's a big project and expect other liens, competing liens to be recorded. The lien will be valid from the commencement of your work and have priority over claims on the property recorded after that. But if there's too much debt on the property, too many lien claims, it may be all for naught. So it's something to examine before putting good money after bad and moving ahead with a foreclosure lawsuit. The final issue that we see is an attempt to lien public property. There's always different rules for the government than there is for individuals, and liens are no exception. With respect to public property, it cannot be liened. There are some exceptions in the case of public-private enterprises such as toll roads. In that case, you may be able to lien the leasehold interest of the private entity, but you still are not going to have an actual lien on the public property itself. As Aaron mentioned, there are other remedies in the case of a public works project, and those come in the form of payment bonds, stop payment notices, primarily. And next, Aaron's gonna go over some of the potential outcomes to mechanics liens.
Thanks, Peter. So I think it's always important to talk about, the tools that are available to you through the mechanics lien, but also what are the objectives, what are the goals of the client that they want to reach, and what are the challenges to getting to that goal, or what should the expectations be. So here's just a simple outcomes matrix that I think it's good to walk through. But on the left side, we have the stage, and this is generally the different stages that a client is going to go through when they have a claim from beginning to end. They're going to start with a dispute and on a contract balance or a change order. They're going to jump to the next step, notice of intent to lien if it's required, record the mechanics lien foreclosure lawsuit, settlement, and then trial and judgment. And so if we go through this, at that first stage, when you have a dispute on the contract balance or a change order, the action really is to preserve your contract claims and demand payment, calendar the deadline to record the mechanics lien. Like I mentioned, you could have just an unpaid contract balance, and that makes you stop work. Or you could have a disputed change order that you performed and is not being paid. And in the disputed change order scenario, it's important that you read your contract carefully, because it's probably going to require you to proceed with some other contractual claim procedure and give notice of that contractual claim. So not only do you have to pursue your mechanics lien procedure like we've been talking about today, you also have to preserve these contractual claim notice requirements. But at this stage, you want to preserve those contractual claims, you want to demand payment, and you want to calendar the deadline to record your mechanics lien. And the expected outcome here is the owner will feel that there's money owed, that you've demanded payment, and they'll negotiate payment with you. And if payment is obtained or a settlement is obtained, you'll issue a lien release. There was a question earlier in the seminar about a conditional and unconditional release. But here, once you're paid, you would give an unconditional lien release showing that you've been paid. If that doesn't work, then you go to the next level of escalation, which is notice of intent to lien. This could be a contractual requirement, or it could also be a legal requirement, depending on which state you're in. And that's simply done by sending a demand letter with the express statement there's a notice of intent to lien that property. Again, the expected outcome is the same, negotiated settlement or payment in full, but you're going to issue a lien release as a result. If that doesn't work, we go to recording the mechanics lien. There we serve the lien and record it. We calendar the deadline to file the foreclosure lawsuit. And again, the expectation is payment in full or a negotiated settlement with a lien release. Then when we get to the mechanics lien foreclosure lawsuit, that's where we're really getting serious now. The lawyers are involved, and now there's additional cost exposure to the client that needs to be given consideration. So here we talked about filing the civil complaint, as well as file and serving and recording the notice of lis pendens, right? Now everybody in the world knows that there's a claim on this piece of property, and the expectation is payment in full or a negotiated settlement. But we have this additional cost exposure that I mentioned about the attorney's fees and costs. And the question is always from clients, well, don't they owe me all my attorney's fees and costs? We just filed this lawsuit and did all this stuff. Shouldn't they have to pay us for that? Well, the answer is contained in your contract, if there's a contractual right to prevailing party attorney's fees. And the answer is also whether there is a applicable statute that gives you a right to recover your attorney's fees. If there are those bases for recording your attorney's fees, you have an argument that you can record your attorney's fee, you can recover your attorney's fees and costs. But the question is going to be determined, or the answer to that question is going to be determined upon what the owner is willing to do or not do. If the owner feels that they have no chances of winning and they're really trying to just avoid any further problems, they may be willing to pay you your attorney's fees and your costs at this juncture. But assuming the case goes forward, it can proceed forward and get close to trial and settle at any point in time from when the lawsuit is filed all the way up to judgment being entered. And so if you enter into a settlement, the parties will memorialize that in a written settlement agreement. And again, the expected outcome is the same. It's either payment in full or it's a negotiated settlement. And the question is, can you recover your attorney's fees and costs as part of that settlement? And then finally, if everything else fails and you have to go all the way through trial and you have to go all the way through judgment, then at trial, the lien claimant is essentially going to prove up that its labor, material, or equipment and service was incorporated into the property and that it's entitled to payment for the work that is incorporated into the property. If you can prove that, then judgment will be entered in your favor, or they will the owner will try to settle before judgment is entered. But ultimately, if judgment is entered in your favor, like I mentioned before, there'll be an order for judicial foreclosure. And now at that point, your attorney's fees and your costs, assuming there's a basis for recovering them in the contract or a statute, now those are going to be paid in full. And so you can see, not only at the beginning of the process here, you're going to have some cost exposure for legal fees and costs, and there's a question about whether you can recover those. Once you get to the end road here, if you have to get there through judgment, if you're entitled to fees and costs, now they're going to be awarded because you are going to be the prevailing party. So this just gives kind of just a list of milestones to be mindful of and what your objectives should be. But the takeaway is, if you intend to receive every single penny that you've paid out of pocket to pursue your lien, you're going to increase the likelihood that you're going to have to go all the way through trial and judgment. If you're more flexible and you're willing to take an approach of not only do you want to get paid, but you're just really trying to defray and mitigate your loss, you're going to increase the likelihood of settling earlier on in this outcome matrix, at the disputed contract balance or change order amount. But at the end of the day, if you're entitled to fees and costs and you do go all the way through to trial and judgment, those will be paid through the judicial foreclosure of the property and taking the sale proceeds and satisfying your judgment. Next, what I wanted to just give to everybody, this is actually off of the Level Set website. It is an example job timeline. I thought this did a very good job of just giving a big picture overview of this process. So not only do you have the outcomes matrix and these different stages and kind of the strategies and what to expect, here you can see, really from beginning to end what the process is. You start your job, you send your preliminary notice, you finish all your work, and you send your conditional final waiver saying, once you pay me, then I've, all my lien rights are released, but for whatever reason, it's not paid. You follow up and you send your reminder, and now it's past due. Now the question is, okay, what steps do I take? And we talked about, already today. You send your notice of intent to lien. You record your mechanics lien foreclosure, your mechanics lien claim. And ultimately, if it's not satisfied within the 90 days, then you file your mechanics lien foreclosure lawsuit. But this just generally gives you, a visual identification of what these milestones are and what you want to keep in mind. So with that, I think we can jump for the last couple minutes of the seminar to some Q&A here.
All right, I'm back here. We do have a number. So if we are not able to get to your question, I posted in the chat box, the website that you can go to post in the level set community, post your question there, and it tags your state. So attorneys in your state can answer about specific state laws, if that applies. So one question back earlier in the presentation was, also for the 60 days of work stopped, is that only if stopped by the homeowner and not the contractor?
Peter, you want to take a stab at that one?
Sure. So at least in California, it doesn't matter why the work was stopped. It's just completion is basically a 60-day cessation of labor for any reason of all labor is going to be considered completion. You've got to keep in mind that's not just a cessation of your work, but a cessation of all work. So if you're a subcontractor, that's not necessarily going to be the deadline if there are other parties performing work. But the reason for the stoppage of work is not going to factor in.
Okay. One person asked if you can just go back to the slide, the timeline slide, just on the screen. And they don't have a question. So Robert asked, I'm both a residential general contractor and a board member of an HOA. We have 66 homeowners in our HOA and on occasion have difficulty collecting the HOA dues. Is using a mechanic's lien to ensure our right to payment a valid option, or is there a different type of lien?
So it is not, a mechanic's lien is not the proper avenue. There are usually through the CC&Rs, there are an ability to lien a unit based on the failure to pay dues, but it's not, the mechanic's lien process is not going to be the proper process for that.
Okay. If we stop work, we cannot list the full contract amount amount in the lien if not all of the work is performed.
That's correct. You can only list amounts actually owed for work actually performed on the project. So you wouldn't be entitled to any work that wasn't done or even profit on work that wasn't done in the context or on the lien. If you have to file a lawsuit, you can include those amounts in your breach of contract cause of action, but it is not a valid part of the lien, and you want to be careful not to include it in the lien because it could lead to a challenge to the validity of the lien.
Great, thanks. Is the preliminary notice the same thing as serving a notice of furnishing?
What state are they in? Does it say?
No.
Yeah, I don't think that we're sure about that. That may be, they do have different names for preliminary notice depending on the state. Sometimes it's just called a pre-lien notice, but I have not heard that term before, but it would depend on your state.
Okay. Who do we lien? Property management company, owner, or apartment, as some examples.
You want to do that one, Aaron?
I'm sorry, could you repeat the question? I didn't hear it all the way.
Yeah, who do we lien? The property management company, the owner, or the apartment itself?
The owner is, it's the property that you're going to lien, right? So that's the nuance with the mechanic's lien is you're actually taking an interest in the property itself. And so based on that, you're going to pursue the property owner. And so if you have like an HOA or something like that, the HOA doesn't own the property. If you have a management company for the HOA, they don't own the property. It's the individual owners of the property that you're going to actually name in the lien and pursue. There's a twist when you have a property that's like a multifamily unit. structure, or it's a multifamily or a multi-structure property where you have different buildings on the same property and different unit owners. In that instance, in your mechanics lien, you want to basically spell out the allocation of amounts to each of those units. But at the end of the day, you're always pursuing the actual property owner.
Great. Next question is, are we required to do the mechanics lien foreclosure process in Virginia within 90 days of filing a lien?
I don't know exactly the time limitation for Virginia, but most states have roughly that 60 to 90 day deadline. And the deadline just makes sense. I mean, again, you're taking an interest in real property, asserting a claim of lien. And so the law is going to expect you to prosecute your rights within a reasonable amount of time. Otherwise, you lose those rights. And so it would be unfair to record a mechanics lien and then just stays on there for years and years. And then, 10 years later, it jumps up and affects a property sale or something like that. So it's going to be probably within 60 to 90 days, but LevelSet has a great state-specific guide to mechanics liens and their deadline. So I would just jump on their website and check there. And it'll give you the correct answer.
Yeah, that's exactly right. And for questions from other states, like an engineering firm in Kentucky, if you want to go post that in the LevelSet community, which you can find that URL over in the chat box, that's a great place to start for attorneys in that state to get their eyes on it and possibly get an answer. And there's also the directory where you can look and search for an attorney in your state and then reach out to them via email directly from there. Let's see. And someone said, go back to the last list. I think that's the chart they mean.
This one?
Yeah, I believe so. Looks like that is all. Aaron, are you able to see one from anonymous attendee at 1:30? It's a pretty lengthy one about, are there any remedies?
Yeah, I think I would say with that one, feel free to reach out if you want to email us, but I think that's a little too detailed for kind of a seminar question.
Yeah, I apologize. I can't see all the questions for some reason either,
Okay.
Unfortunately.
Well, we're right at time. Thank you guys so much for the presentation today. I know it was really informative. We got some comments thanking you for this seminar, and everyone attending will receive the recording and slides, the presentation material, in an email Friday. So if you were here, you're on our list. And again, if you have any questions, you can email me about CLE certifications and how to get credit.
Thank you, everybody, for joining us.
Thank you.
Well, that concludes our webinar today. Bye, everyone.